Welcome to Q&A. I'm Attorney Kendra Cooper, your host for today's program. Our topic today is the June 1st, 2010 Supreme Court decision, Thompkins, which we believe will have a tremendous impact on our Miranda rights that nearly every American knows about but may not realize has been lined up for a major change. There's a great deal of concern about this new decision because it erodes the right to remain silent and the right to have an attorney present when questioned by the police. My guests today are two criminal attorneys. Jay Milligan practices criminal law in Massachusetts, and Mark Stevens practices in both New Hampshire and Massachusetts. So welcome to both of you.
Thank you.
Could either one of you explain, would you like to explain a little bit about what
the Miranda
has been?
Sure. The Miranda decision came out in 1966, and it was a pronouncement by the Supreme Court to the police departments across the country so that people would be advised of their rights in a uniform way, the primary rights being the right to a lawyer and the right to remain silent. So police departments were doing it differently. Some were advising people of their rights, some were not, prior to Miranda. And Miranda says that a person arrested or in custodial or in custody has to be advised of those two important rights. And it goes like this. You have the right to remain silent, you have the right to a lawyer, you have the right to cut off questioning, you have the right to have your lawyer present during questioning, and you have the right to an appointed lawyer if you can't afford one. So that is what Miranda basically is. And Miranda boils down to that right to a lawyer and the right to remain silent. How this case changes that is that in the past, if a person simply remained silent and never waived his or her right to remain silent, then the silence couldn't be used against them and the police would have to cut off questioning eventually. What this case holds is the proposition that if a person doesn't affirmatively exert their right to remain silent, then it's deemed a waiver, basically. The police can just keep going like they did in this case for 3 hours until the person eventually broke and said something. There's a jump ball as to whether this is considered a confession or a break or breaking based on the way that the questions came out and so forth. But it is a sharp departure from what had been happening before.
What kind of cases would Miranda normally come up in anyway? I mean, for some people who haven't really encountered this kind of
yeah, and they hope they never will. Yeah.
I mean,
it comes up when you're in custody. So custody doesn't necessarily mean a formal arrest, but it can be, you know, the Miranda decision talks about being swept from familiar surroundings and into the pressures of a police questioning type of situation. But it can come up during an arrest, during a roadblock, come up during almost any sort of police encounter that kind of ripens from the initial conversation to, okay, now we're focused on you, we're going to try and get you.
More information. Often
Right.
they will ask. They will present it to you as they just want a little more information, or you can tell your story.
Sure, Kendra, tell us your side of the story, okay?
Right, okay. But instead...
That side is not a good side to convey.
Yeah. Now, do you encounter Miranda a lot in your current practice? I mean, the way it is now, well, the way it was prior to this June 1st decision.
Oh, sure.
Right. I mean, Mark and I, you know, in handling the OUI cases, you know, we file Miranda motions on just about every single case.
Right, so operating under the influence cases, OUIs.
Invariably, there are statements made, and every case is different in the facts in which the statements are made. As Mark said, you need a custody and you need interrogation. On every single stop, the determination of custody is different. Whether or not a person would feel free to leave at that point, whether or not the officer is asking him what's termed preliminary questions or interrogation, whether they're looking for information basically designed to convict you. So every case is different. So this case is literally going to impact every single operating under the influence case that we handle and the motions that we file on their behalf.
Is this just in a police station, or could this be in other circumstances?
No, as Mark had indicated, it doesn't need to be in a police station. It needs to be in an environment with which a reasonable person would feel that they're not free to go. It's not associated with a, you know, click, click,
so
you know, handcuffs are on you.
Or it could be
in a road.
Them stopping you on the street.
Sure.
It could be by virtue of the number of police cars there, the number of officers there, the environment that's created by them, their presence there. A person who's surrounded by 5 officers is not going to feel like they can just walk away from that scene. You know, that could be a case where custody is essentially attached, and if they start asking you questions, whether it's drugs, guns, alcohol consumption, that is an interrogation, because those answers, trust me, are going to be used against you.
If they came to your home, would that be a circumstance when
you know,
sometimes people feel polite when people come to their home.
They shouldn't do
polite,
that.
But they,
They shouldn't.
they
shouldn't be polite.
At least when it comes to your home.
Right.
Don't be.
You know, generally.
Well, I'm just trying to think of when. You know, when would people think that they should have had their Miranda rights read to them?
The problem with a lot of people's perception of this is that they don't realize how important these rights are until it's too late. And the cops have asked you questions, and you're raised to respect and obey cops, and be a law-abiding person. And they say, "How many beers have you had, Kendra?" "A couple, huh? How do you feel? A little buzzed?" You're about to be arrested. They just haven't said the magic words yet. They're about to put the cuffs on you, and they're going to argue that you weren't in custody when you answered the questions. But the question, like Jay said, is it the functional equivalent of custody? Have they taken your keys? Have they taken your license and registration, separated you from your vehicle and your passengers and so forth? And they're just about to arrest you. They're just being clever and waiting and saying the magic words after you confess.
So to get to your point about home, I mean, generally the cases will talk about a police-dominated environment. If you're in your home, you know, that may be a tricky issue. Certainly you're going to file your motion.
Don't let them in.
Right, don't let them in.
Well, if you've got 2 or 3 policemen in your living room, what?
Right, it depends.
Tell them to leave, I guess, you know.
If others are present, how many police officers are there, what are they wearing, are there guns displayed? I mean, there's a number of factors that can be considered by a judge in determining whether or not the person was free to leave, whether or not that person is the actual suspect or target of the investigation. Those would be all factors that a judge would look at in determining whether Miranda was applicable.
And Miranda actually was a case in which there was a person named Miranda. That's how these cases come to be known. Though most of us think it's our rights, and they're just associated with the rights. But there actually was a person who exercised, or they explained did need to exercise his rights, and had the right to, and. That's
right, and that decision, that was one of these custodial interrogation cases that rose to the Supreme Court, and it became clear, if you read that decision, that there was a disparity in how cops all over the country were advising people of their rights, if at all. And they said, look, you've got to do this. Yeah, it's got to be standardized, and to make it very clear to all the police across the country, you've got to do it, and you've got to say this. The language is very specific. And the language was read to Thompkins, it appears, from the record of this.
Right. Yeah, I think you have something that's what Thompkins. What was the actual case that has just been determined? What was the circumstance? It
was a murder case, and they were questioning Thompkins. They read him his rights, and it looked like the Miranda rights that they read were correct. It looked like they were appropriate. And Thompkins was basically quiet, or nodding his head, or just saying yeah, stuff like that, not answering any questions directly for close to 3 hours. And then eventually. And I think he complained about the seat being too hard or something like that. But he obviously wasn't having a good time in there. And at about the 3-hour point, he made an incriminating statement.
Right. Yeah. But all this time, he had remained quiet.
Right.
Pretty much silent.
After he's told he could remain silent, he did. For the most part.
Which is what people normally tell people to do.
Right. That's what we tell everyone to do.
And another factor in the whole thing was, once they gave him the rights form, he did not sign them. Did not sign the actual rights, acknowledging the fact that he understood them. And in this Thompkins case, part of the disturbing part of it is, A, he didn't sign it, and B, there was some discrepancy in the evidence as to whether or not he verbally indicated to these officers whether or not he understood them. And again, as Mark said, he went 2 hours and 45 minutes of a 3-hour interview, basically sullen, not quiet, not saying anything, just letting these officers kind of run him through the ringer. And he just sat there. And then at the end of it, he made an incriminating statement, which for all essential purposes, given the facts of the case, resulted in him being convicted, because it wasn't a very strong case for the government against him.
And the thing with this is, too, is prior to this, there had to be an express unambiguous waiver under North Carolina versus Butler. And there's a difference between understanding your rights, and the other shoe to drop has to be that you waive them affirmatively, either in writing or saying, yeah, I waive them. And like Jay said, neither one of those is present here. So the Supreme Court grafted his response to the questions as a waiver. In other words, they said, you've got to say, I want to remain silent, or you've waived it, which was not the case prior to that. Usually they sign it, yes, I want to talk to you, or no, I don't, or will you waive this, and the officer will write in his notes that he said, yeah, I'll talk to you. And it's simple enough to ask him to do, but there's no record of that here.
To me, that kind of protracted interview or interrogation is a better word for it.
3 hours with Jack Bauer.
3 hours with Jack Bauer, that just seems to me that
eventually
it was a real duress.
Absolutely.
And in the past, that would have counted as
right.
being, we'll just throw out any statement he made, because I mean, who's going to stand up for 3 hours?
For 3 hours in the nature of the crime. It's an accusation of murdering someone.
Yeah.
That's a tremendous amount of pressure, whether you did it or not. He certainly knows he's the suspect in it.
Right.
You know.
It goes under voluntariness. How much can a person take before they're gonna say something either that's not true, or just say something that just tell the cops what they want to hear.
Get it over with.
Or even misunderstand. Now, one of you are actually I have it. The exact 3 questions that were asked him that he ultimately made an incriminating statement from. The first question was, "Do you believe in God?" He said yes. "Do you pray to God?" He said yes. "Do you pray to God to forgive you for shooting the boy down?" Yes. And I'm sure that he said it faster than I just read that. But
right.
When you listen to that and imagine almost 3 hours of quiet, not saying much of anything, and then suddenly something, yes, you're saying yes, yes, yes. People want to please. I mean, that's one of the problems too. So I even wonder if the person really heard the last part of the sentence correctly.
And it's kind of like the old, when did you stop beating your wife? Do you pray for forgiveness for shooting that kid? It implies that you shot the kid. Do you feel bad about it?
Well, and if someone is truly religious, they probably have been praying for the person who died.
Yeah, but the cops would leave them alone.
It's a technique. It's as trial lawyers, you get a witness to start saying yes, 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 yes. Then you sneak a bullet in there, and you just get them to go with the yes answer, and then you've got what you need.
But in this case, that one word yes is what it was a self-incriminating statement, and that was the only one. Whereas before this court decision, that wouldn't have held under Miranda.
Right. If you looked at the clear line of cases with North Carolina versus Butler, if he didn't expressly waive Miranda, particularly given the length of time that he's talking to them, this probably would not have come in.
And when you say expressly waive, you don't mean just in writing. It's just you have to make a very clear statement that you...
Well, Butler is absent that express written waiver. There has to be some evidence that he affirmatively waived. So you can do it verbally. They can say, I could say, Jay, I've read you your rights. Knowing those rights, would you like to still talk to me? And he could say yes. That would be a valid waiver, but that didn't happen here. In fact, I think it's because they never asked him to.
Right.
So if they never tell you that you can waive these rights or hang on to them, and they just keep asking questions, anyone's going to think, when is this going to stop? I just want it to end.
Yeah, I mean, for the average person, they're not going to know that they have to affirmatively assert that they want to remain silent. And so for the person that doesn't want to answer questions, and just sits there and doesn't do anything, now that's going to be a waiver. I mean, you have not asserted your right to remain silent. And they're going to argue that's consciousness of guilt. I mean, it can go anywhere the government wants it to go. He didn't answer the question because he felt guilty, or he didn't have the answers. The answers were going to be incriminating. It has a dramatic effect on how cases are now handled.
And the question that still remains out there is how well somebody's silence. What if somebody doesn't waive? They won't say, yeah, I'll talk to you. But they also won't say, I want to remain silent. They don't affirmatively exert their Miranda rights. They just sit there and clam up. They either don't know the question, they don't understand the question, maybe they don't speak English. Will that silence now be used against them? Which it currently is not. That's not addressed in this decision, so that's another concern. I have clients that just won't talk to cops. If they interrogate them, they won't say, I want to remain silent. They'll just sit there and be quiet, go to jail and get bailed out or whatever. Will that silence now be used, like Jay said, as an admission of guilt? Who knows?
Not to mention the fact that I'm not even so sure the police departments are going to be complying with this. I mean, all these forms in every single police department, state police, all have pre-printed forms which essentially follow the old Miranda rule. So the question is, are the police going to start following this? If so, how are they going to change it? And as lawyers, we need to start advising our clients differently. I mean, Mark and I, for instance, have our cards with rights on the back. Mark's are new, so his comply with a new decision, Thompkins. Mine are old. I literally need to change my cards and the advice that I would give to a client. So it's going to be a roller coaster, and we'll just see where it goes.
With this change, though, do they still have to read them their rights? I mean, the Miranda rights.
Yeah,
they still have to go through this list of.
Yeah, I think we still have a couple of rights left. This doesn't change that.
But there's a different understanding of them.
Right. This goes to the waiver of the rights more than what the rights contain. You still got a right to a lawyer. You still have a right to shut up, and you just have to exert those rights now.
You have to say, when you say exert them, you have to make a conscious effort to say, I do not want to speak with you.
I want to talk to my lawyer. I don't want to talk to you. I want to remain silent.
My guess is, though, however, the police are not going to tell you that.
Right.
They're
See,
not.
that's why I'm
they're
saying,
not.
are they-
So while the old Miranda form is going to be the same, they're not going to say you have to affirmatively assert your right to remain silent, not to talk to me. They're not going to tell people on the road that. It's just not going to happen. Now, when they get back to the booking, I'm sure there's going to be a nice printed form that complies with the Thompkins decision at some point. But out in the roadway, where it's just the officer and your client.
And a card he's carried in his pocket for years that he reads. He reads from. He or she reads from.
She said. He's going to say, yeah, of course I advised them of that, and they chose to speak to me.
Yeah.
It's open. It opens up the door to a lot of issues and a lot of incriminating statements that are eventually going to now come in that otherwise would not have.
I think, like Jay touched on, is that going to be part of the form that has to be read to them at some point, and at what point? You know, do they have to tell them you've got a right to exercise your right?
But this case really doesn't say that they must tell them, that they must affirmatively act. Actually,
well, I think it does. It does in the negative, right?
In
it
the
does,
negative, but it's
right.
not. It doesn't put the responsibility on the police to tell them.
No, it puts it on the
But
defendant.
on the person who maybe
Right.
has never been stopped, or maybe has no idea that they not only have the right to remain silent, but they have the responsibility almost to
Absolutely,
to state
yeah.
that
It tells them
they
they've got a
want
right,
to be,
but now,
and they are not waiving their rights
right,
to remain silent.
right, and like you say, it's the first timer that this is a problem for, and most of the people we get are first timers and last timers. They're only arrested once. This is the one bad experience they're going to have. There's no way they're going to know this unless we start communicating it.
The problem, it leaves it open to interpretation as far as what they need to do. And if the officers have an opportunity to interpret something that favors them, I would be willing to bet that they're going to interpret it that way. And again, to the detriment of somebody who otherwise may not have answered any questions and would have asserted their right to remain silent.
Had they known, you were talking earlier about people understanding. Often when clients come to you, they talk about knowing their Miranda rights, and this is. I mean, and I know you watch Law and Order, or you watch.
I don't watch Law and Order, no.
You don't, no. But a lot of people do.
And none of our clients confess at 5 minutes at 10 with us sitting next to them.
Judge Judy, or some of those things. I mean, some of those reruns are not going to be very good for people now if they watch them.
No, if you watch the old Dragnet show, the warning's no good.
Right.
You know, because Jack Webb doesn't tell them, oh, and would you like to exercise your right to remain silent? You know, it's not.
And one of the first things when people come into my office say, oh, well, so-and-so didn't read my Miranda warnings, or so-and-so, can I get my case dismissed? And you got to explain to them the implications of Miranda, because nobody really understands it. Everyone's heard Miranda, but they don't understand when it's applied. And so since they didn't understand it then, when it was firm law since 1966, they're certainly not going to understand it now, and there's going to be a lot of confusion around it. And that's, as I said earlier, going to be a real problem.
There was something I was reading that talked about Miranda too, and how a lot of times people said they understood Miranda, or they knew about Miranda, but they really then they would waive it. I mean, this is in the past, because they really didn't understand. They would say, "Oh, I know my rights," and then they would just waive it anyway, and then they would continue to talk. But in this particular case, in this Thompkins case, he really didn't. He didn't continue to talk.
No, he just responded in one-word answers to what they asked him.
So that isn't really.
He would do everything that a lawyer would advise him.
Up to that point,
Thompkins.
right?
Do not say anything. He did exactly what I would advise him. Don't sign the form. Don't talk to them. Remain silent. And he did exactly what a lawyer would have advised him to. And,
Prior to this, right?
Prior to this.
Yeah, which is why it's time to change your cards if you've got advice on the
Yeah,
back.
mine say did.
I got to call the print shop.
You have that instead. So another question I had to do with, now the federal law in this U.S. Supreme Court decision is the law of the land, but sometimes states can have more stringent requirements. And I was wondering how you see, like both in New Hampshire and Massachusetts, how do you see this paralleling or dovetailing with what we have in our in Massachusetts right now?
Well, I mean, first start off with the fact that this Thompkins decision was a close decision. You're talking about a 5-4 vote. So I mean, it was a very, very close issue, and as you indicated, Article 12 of our Massachusetts Declaration of Rights deals with the Fifth Amendment. So the Supreme Judicial Court in Massachusetts does have the authority to hold a more stringent requirement, basically keep it the way it is.
require the police to have more substantial...
Or just keep Miranda in place in that someone who remains silent and doesn't affirmatively assert it is in fact a right to remain silent. They do have the discretion, the authority to hold that here and not go along with the Thompkins decision, because that would be, I guess, holding, tie goes to the runner when you're dealing with the Constitution. That would be protecting the rights of somebody more than what was done here in Thompkins.
Right.
Okay, yeah.
All the states have the right under their state constitution to decide something on what they call adequate and independent state grounds. And some states choose to do that, some states choose not to. And Massachusetts and New Hampshire both do decide things on constitutional issues on state grounds. So what Jay and I are hoping is both of those states' Supreme Courts will eventually, this will get to them fairly quickly, give the citizens in our two states more protection than the federal government does.
Well, that's hopefully, will happen. I know there's some...
And Miranda is one of those areas of law where they tend to, where the, yeah.
Well, I know I have a friend who practices in Florida, and she's seen some major differences.
They don't.
No, they don't. It's bare constitution down there sometimes, on some things. But in particular, that's why from state
if they're
to state,
lucky.
people, and even when they travel from state to state, people are driving down, sometimes they need to be aware of some
Don't
of the
confess
laws
anywhere and you're safe.
Don't confess anywhere. Yeah, that's right.
There was, go ahead.
No, that's right.
There's one upside to this Thompkins decision in that Judge Sotomayor wrote the dissent, and I think it was one of her first dissents. So from a defense perspective, and seeing her with this, great dissent, from a defense perspective, it shows at least some of her colors here and what we can expect from her in the future. So in that regard, it's a great dissent by her, and hopefully she follows this party line in the future.
One thing too, I think that this will do is it'll raise some attention to people that don't plan to get arrested or don't, aren't plotting a crime or anything, but the average citizen. This case is getting enough attention that it will draw some of the concerns out, and people will be more aware of their rights and the fact that they have to exercise them affirmatively now. So.
Yeah, I think one of the things that at the end of Sotomayor's decision, she or her dissent, she actually describes that decision, the Thompkins decision, as being of turning Miranda upside down. She said the criminal suspects must now unambiguously invoke their right to remain silent, which counterintuitively requires them to speak. So at the same time, the suspects will be legally presumed to have waived their rights, even if they have given no clear expression of their intent to do so.
Right.
They can in this case with Thompkins, maybe that's probably what he did. He had no idea that he was waiving.
That he was waiving anything.
Remain silent after almost 3 hours of being silent.
Right, and in one paragraph, she sums up a 20-page decision on what Miranda was. It's spot on, and it leaves attorneys like Mark and I looking and shaking our heads and say, how did they come up with this? Given this particular fact scenario, it leaves you wondering where our Constitution is going.
It is counterintuitive, because if I tell you, okay, Kendra, you have a right to a lawyer and you have a right to remain silent, you think, sounds good. I'll sit here and not say something.
Yeah.
I'll not say something, and I badge you and don't let you out until you finally say something. And is that a waiver? I guess it is now.
So at the base level right now, for the average citizen who may be stopped now and questioned by the police, what do you think that they should know now?
If you're in the process of committing a crime, whether it's
or whether you didn't know,
or someone thinks you are,
or whether you think you're committing a crime, or if you've had a couple of drinks and coming home, or get drugs or guns, whatever.
Or even if you're just accused. Sometimes people are accused of things they did not do.
Sure.
Or, if you think you're the target of an investigation.
Right.
Very simply, I do not wish to speak to you. I want to assert my right to remain silent. Period. That's it. End of story. It should be left at that, and hopefully that the law enforcement will respect that, as they should, and arrest you. Because whether you assert that right or not, there's one place you're going, and that's usually in the backseat of a police car.
Do you have anything else to add to?
Yeah, they should do two things always. Two things: lawyer up and shut up. That's what I tell people. Lawyer up and shut up. So when the police start asking questions, say, "I want to call my lawyer," and be very clear, "I do not want to talk to you." Okay, it's not going to help you.
I think sometimes people don't really, especially if they had no experience at all.
Sure, they feel like, oh, maybe he seems like a nice officer, maybe I'll just tell him my side of the story. And then they hear the click, 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 click. Right.
Yeah.
Right, and they don't want to be embarrassed by, the police sometimes are, they're clever at what they do, and they'll say, well, you want it to be that way, huh? You don't want to tell us what happened. You don't want to tell us your side of the story. Now's your chance, and it's really not a good chance. And as embarrassing as that might be, just remaining silent, it's not as embarrassing as hearing a confession read to a jury. So you're always better off just saying, I want my lawyer and I want to be quiet, and stick to that and don't break. And your case will be much better.
Because you need to remember, the police are not there to figure out what the truth is.
They think they already know.
They're there to make an arrest on probable cause, which is just whether or not they think something. And that's real easy standard. So if they think you're intoxicated, they think you have drugs, or they think you have a gun, they're going to arrest you anyways. So if you're in that situation, the best thing is, like Mark said, ask for your lawyer and don't speak to them, and tell them that.
And it really is, and affirmatively say, I want to remain.
And when we say this, we're not saying that the police are doing anything underhanded. They really think you committed the crime. You're the suspect.
Right,
in their minds, they think you did it, and they're trying to get you to convict yourself. Okay, so the best evidence that they usually have are the defendant's statements. Whenever we look at a case, the worst part of it usually is the things the defendant said, what he or she told the cops. It's not what they did. It's not their balance. It's not any physical evidence against them.
They may not even realize how they stated it.
Right.
That it might be saying something to someone else is not what they mean. A lot of people aren't very literate as far as
sure. If at any time a person says, for instance, oh, I'm sorry, to the officer, they bump into him, they do anything, it's going to come out in the police report that they felt sorry. What does that sound like? It sounds like they're sorry that they did it.
Right.
Like this guy saying yeah to that question that was the confession.
And he said yes.
And Thompkins, he said yeah, but he had grunted his answers all the while. They'll take seemingly innocuous, in your mind, answers to something and turn them into incriminatory statements, and they just sound bad. Anything you say in police custody sounds bad because they're asking the questions, they're giving you the format on how you're going to answer, and the questions that they ask are very narrowly tailored to convict you. So it's best to say nothing at all and be the quiet mouse and just wait to get bailed and call me.
Talk to your lawyer. Yeah. So at this point,
call Jay.
basically, call Jay, call Mark. So basically, this is how you look at the changes to Miranda, and actually, it's not so much change to Miranda, but it's change to the way it's applied.
Right. No, we started telling people. I know I have in the past. I tell them, listen, always ask your lawyer. Always just say nothing at all. Now I'm telling them, make sure and ask for your lawyer, and make sure you tell them you don't want to talk to them. Yes. Right early on. In this thing, and that should terminate it. Like Jay said, good officers, I think, will honor that and terminate it, and just make a note of it.
Well, thank you for coming today. I know this has been a hot topic. A lot of people have been discussing it, and I really appreciate your kind of bringing it out a little bit more into the public eye, so that people will be more informed.
Thanks for having us.
Thank you, Kendra.
And thank you for watching.